May I mention a matter, my lord, upon notice, my lord. Under compelling circumstances, I am mentioning, my lord, I am the banker, my lord. My security has been directed to be released. Auction has been set aside. But I have a lien. There is a specific pledge of these gold jewelries with the borrower's others loan, my lord.
It is running in the list or is
It is running in the list. Yesterday it was item number 72 because they are coming. They are asking for release of the gold jewelries, my lord. I cannot.
please give.
My lord. Deeply. My lord,
Yeah,
I noticed a name.
May I, my lords, kindly leave to mention a matter, my lord. My lord, this is the matter your lordship will remember regarding the refund of the stamp duty and registration charges and other charges.
Yes.
My lord, this matter appeared in your lordship list on 7th of August. And then the state government took instruction in your lordship list to adjourn till 23rd of August. Since then, the matter is, let the appear, my lord, before puja, because I am a cheat fund, my lord, to pay the borrowers the money. I have no fund in my hand.
My lord, I'm mentioning upon notice, my lord. My lord, under compelling some circumstances, my lord, my land, homestead land is sought to be used as a high tension electricity corridor. My lord, it has to be done. My lord, section 10D has been given a complete go by. Section 10D of the Telegraph Act. That is my only protection. It's been given a complete go by. No notice was properly served, my lord.
If you raise an objection, the district magistrate has to.
My lord, I know, my lord. The district magistrate has given a hearing, my lord, before the single bench. My lord, my issue was it's not.
It's a fresh appeal.
But district magistrate heard me. It was a. It's a fresh appeal.
Fresh appeal. Yes.
Monday it will be. Monday at top. Because Monday it will be heard by the district magistrate's hearing was over. It was nothing. No order was passed yet. Nothing was done. Everything is circumvented. Kindly, and they have come before the court and said that
Monday or Wednesday. When it will come? Wednesday,
because Monday is the hearing, my lord. Monday, why, my lord? Monday they have called me before the district judge. Monday they're giving me a hearing. They have given everything a complete go by.
My lord, may I have a lawsuit leave to mention this recalling application? My lord, this was public interest litigation was disposed of by your lawsuits on the 18th of the September. My lord, I was a party to this by the private respondent. I have not been served first. Impression was created before lawsuit that service has been made. Secondly, there is a suit pending between the petitioners and myself. That has been totally suppressed. I'm enjoying an interim.
List the application.
Well, kindly do that because your lordship has certain observations has made and directed the district magistrate to take action against me. If that is possible, that's the only problem.
Wednesday will do.
Not the public interest litigation.
Oh, Monday.
But may I have your lordship's kindly to mention one matter, my lord, pursuant to my lord's direction, my lord, on 8th June, my lord, a building is sought to be demolished, my lord. We preferred an application for review. It is appearing in the list, my lord. My prayer is, my lord, some precedents may be given.
What is the serial number?
Today, my lord, it's appearing as item number 98.
98. We will try to upgrade it. You give the letter.
May I have your lordship's kind leave to mention APO 107 of 2023. Your lordship, it's running at item number 39 of the monthly list. The urgency, your lordship, is a penalty order which has been passed under section 270A of the Income Tax Act on 25th September. Your lordship, the matter may kindly be fixed.
We'll do something. Probably next week.
Lordship, any day after 12, subject to your lordship's kind consideration. Grateful to your lordship.
With your kind permission, I would like to mention one matter. I have participated in the tender process, and I have a successful bidder in that of a cooked diet mental hospital in Purulia. So after that, I have done my work properly, but the CMOH has stopped the work order of the applicant. So they are not paying the bill. And according to my instruction, Millard, he has taken some money, borrowed some money, and he has done the bidding and stuff.
And
so he's not getting
what happened to your writ petition?
Millard?
Your writ petition was dismissed.
Yes. They are not paying the bill, and the thing is that
it's a fresh appeal, or is it running in the list?
It's running in the list. I would like to upgrade it, Millard, because
serial number.
It's 148, 149. Millard, please keep it on Monday. I mean, Wednesday at the top, Millard.
Let us see the file and we'll take
because it. Because if he is not able to get the money, then he'll be in the haunts of a dilemma, because he won't be able to pay the borrower also, he won't be able to get the money.
Yes.
Keep it in the top, Millard, Wednesday.
My lord, may I permitted to mention, my lord, ki file the appeal, my lord, without certificate copy.
Leave granted.
Lordship, this serial number 92 of the today's list, Lordship. This was regarding that advance ruling, whether a recipient can seek advance ruling or not. Post your lordship's order, the authority called us, they did the hearing. Now, in the meantime, because one authority is WBGST and another is CGST. So now CGST told that we will prefer an SLP. So they have not preferred that also. And in the meantime, they have not passed an order also. And Lordship, we filed a contempt. Your Lordships on 1st of September ordered to We have given the notice also, we have served them. In fact, Lordship,
Contempt is item
92.
92.
Lordship,
You want to
in
upgrade.
fact, Lordship, what is happening? It was regarding the tender with KOPT. Now KOPT is charging us damages because they are saying you have neither taken the land, you have not paid us the amount.
You give the number.
Lordship, I have given yesterday also.
Let us see.
I'll give a
Please
mention.
note down 92.
Lordship, in fact, just once, Lordship, yesterday the CGST panel council, they stated now they are agreeing. Just if this honorable court can fix a date of hearing, they will, because the new member has come in CGST now.
All right.
So that was any day next
Yes,
week, Lordship.
Yes.
My lord, may I be permitted to mention, my lord, item number 71 of today's list, my lord. It's a seizure matter under the Customs Act, my lord. Every Friday it is appearing, but we are mentioning because the goods are lying seized, my lord, still.
What are the goods? Beetle nut.
Goods are betel nuts, my lord. Your lordship
We'll see.
remember.
Yes, Mr.
My lord, I'm mentioning item 42.
Ah.
My lord, in this matter, this is pending for quite some time. My lord, the difficulty is that my registration is cancelled, so I am already dead. But but now my customers are receiving the notices because my registration cancelled with retrospective effect. So there is a
We'll try to upgrade it. If you don't reach today, we'll upgrade.
My lord, I am
what-
seeking
what-
intelligence, my lord, once. My lord, if your lordship will not take the matter today, kindly make it on top of the list on the next Friday, my lord.
We'll do that.
My lord, item 88.
Ah.
My lord, this is a contempt matter. Your lordship issued notice, my lord, last month. So, my lord, if this can be heard someday, my lord, because your lordship directed for passing of the order on merit
All
last year.
We are noted down. Let us see.
May I be permitted to mention, Madam Mallet? Mallet, this is I am for the ECL authorities, Mallet. But here, Mallet, we have banned the petitioner, Mallet, for more non-performance, Mallet. Challenging the banning order, Mallet, he has come before the honorable single bench. Honorable single bench, Mallet, had set aside the banning order, Mallet, and had directed us, Mallet, to allow him to participate. Now, the honorable single judge has not granted us opportunity to file affidavit, Mallet, to bring our
It's a fresh appeal.
My lord, this is an appeal. This is by pending before your lordship. Please, my lord. Yesterday it was that's item number 98, my lord.
Today it's not there.
Today it's not there, my lord. Now, my lord,
Oh, group
residuary
9.
matter, my lord.
So
Now
it will
my
come,
urgency is this, my lord.
next Wednesday it will come. Let us see the next Wednesday.
My lord. My urgency is that they have filed a contempt, my lord, and this is pending, my lord.
Give the number. Try to upgrade.
My lord.
Ah.
My lord, if your lordship remembers, my lord.
Yes, that matter. We remember.
My lord, I am stuck as because 4 crore rupees is with them, my lord. Lordship has directed them to come with the instruction what to do about that, my lord. My lord, for a businessman, my lord, from January, my lord, he's suffering that everything is stopped, my lord. Even now the puja
what is
bonus,
this?
my lord, he is unable to pay the bonus, my lord.
What is the serial number?
Serial number 72, my lord. My lord, grateful.
My lord, may I be
Should I give the list?
Yes.
হাইকোর্ট গ্রুপ ডি স্টাফে আমরা কেস করেছিলাম স্যার।
Pardon? Use the mic.
হাইকোর্ট গ্রুপ ডি স্টাফ স্ক্যাম কেস করেছিলাম স্যার। মামলাটা একটা হিয়ারিং হয় স্যার, ওইটা রিলিজ নিয়ে এসেছি আমি স্যার। আর্জেন্ট হিয়ারিং যে
You give the letter to the secretary. We will do it.
সেক্রেটারিকে একটা চিঠি করে এটা দিয়ে দেবেন, ওটা নিয়ে সাইন করবেন।
My lord, may I be permitted to seek leave to file one mandamus appeal without the certified copy, my
Yes, leave grant.
Grateful.
But it's all the list.
My lord, one request, my lord. There are several constitutionally validity matters which are pending for learned single judge. So, my lord, I am requesting in one of the matter, my lord, there is a direction of the Honorable Supreme Court also by order dated September 2021 for expeditious disposal of those kind of matters where section 16(2)(c) has been challenged. So, my lord, I am praying if, my lord, these matters can be assigned to some bench or, my lord, I had already.
You give a letter on the administrative side.
I give a letter. Grateful.
Appellate side, daily list, serial number 1.
What is
my lord, I am for the petition.
Only that, Mr. The case number is wrongly mentioned. Matter has been listed under the caption to be mentioned. It is submitted that the case number has been mentioned as WPA within bracket P 7727 of 2018, whereas The correct case number is WPA 7727 of 2018. This correction be effected in the order passed in the writ petition, and this order shall form part of the said order. Next.
Serial number 2 and 3.
Okay. Matter has been listed under the caption to be mentioned. In the order dated 7/8/2023, the along with the writ petition, along with the writ petition, Can 2 of 2020 has been mentioned, whereas the correct number of the application is Can 2 of 2022. This order, this this mistake be corrected in the order dated 7/8/2023, and this order shall form part of the said order. Next.
Serial number 4 to 29.
My lord, in respect of serial number 4, this slide, my lord, different from the other matter, my lord. Although this relates with the panchayat election, this matter is relates with regarding the compensation to the person who has expired, and my lord,
That is also arising out of the.
Yes, yes,
Your
that's
lordship
true.
wanted
And-
me, my lord,
and-
to, that's right, to
Yes,
file an affidavit, my lord, showing, my lord, who, my lord, are the dead persons to whom compensation has been paid.
Yes.
My lord, I've done that. And my lord, who all have been given, my lord, a job. My lord, my lord, that also I have done, my lord. So, my lord, may I file those affidavits and give my learned friend a
Please
copy?
you verify and then do some cross verification also.
If any rejoinder is required, my lord, I will file my.
In which, what is the date of the order, sir?
My lord, that order, my lord, your lordships will find, my lord, is, my lord, dated, my lord, 20
and 9.
My lord,
Main matter.
18th September.
18th September.
By order dated 18th September 2023, among other things, the appropriate authority of the state government was directed to file a report in the form of an affidavit disclosing certain details as mentioned in paragraph 5 of the said order. The learned Advocate General, appearing for the respondent state, has placed a report in the form of an affidavit filed by the Special Secretary, Home and Hill Affairs Department, Government of West Bengal, dated 3rd October 2023. The said affidavit is taken on record, and copy of the affidavit has been furnished to the learned advocate appearing for the writ petitioner. Liberty is granted to file an opposition if they so desire. On the earlier occasion, the court had adjourned the matter so that the writ petitions can be heard after the disposal of CPAN number so and so and so and so. CPAN number 3831 of 2023 and CPAN number 948 of 2023. Those contempt petitions have been directed to be are being heard, and the next hearing date is fixed on 11/10/2023. Hence, these writ petitions may go out of the list and to be included as soon as orders are passed, either interim or final, in the contempt petitions.
Grateful, my lord. Lord, item number 5, my lord. The contempt application, my lord, stated challenging the formation of board. My lord stated that we will take hearing if my lord can fix.
We will take.
Lord, may I just make one prayer?
Yes, sir.
It was his pleasure to record that liberty to mention in these matters after disposal of.
Yes. Liberty is granted to the learned advocates to mention for listing of the matter. All right. Item number? The affidavit of service filed in WPA P 386 of 2023 is taken on record. Next.
Serial number 30.
Actually, I'm appearing for the. My lord, I beg to appear for the alleged container, my lord. For some, I am
My
praying
contempt
for,
application, ma'am.
my lord, I am praying for some time
Why?
for my lord compliance of your lordship's order, my lord.
You file an affidavit,
If my lord,
affidavit saying that we will comply the order in its letter and spirit. Please give us 1 week time, 10 days time, 7 days time, 12 days time.
Let that be recorded, my lord, because I'm suffering from a lot of
Yes,
time
yes,
and
yes.
I already my
But
period of
your-
service is also at the end, my.
Your client, you got instructions from your client that they are going to comply with the order.
my lord, they are going to, my lord, discuss the file has opened, my lord. I have been over telephone, my lord, has been told that we will be complying the order.
But
And
that
if it,
oral
my lord,
statement, don't take the risk. You don't
lord,
take the risk.
my lord,
You
my
ask-
lord, may I get 1 week time, my lord, to come back with instruction, my lord?
No. What we'll do is we'll list the matter on Monday.
My lord.
On Monday, you file the short of 1 page affidavit saying that within what time you will comply.
I will be coming back, my lord.
We have heard the learned advocate for the applicant and Mr. So-and-so learned advocate appearing for the
Alleged content.
alleged contempt.
In item number 30 only, my lord.
The learned advocate appearing for the respondent submitted that he has telephonic instructions from his client to state that the respondent alleged contemnor requires time to comply with the judgment and order dated 23/12/2022. Let an affidavit be filed by the appropriate person of the alleged contemnor to the said effect on the next hearing date. List the matter under the caption for orders on Monday.
Much obliged.
Serial number 31.
31 is also the same matter, my lord.
Same matter.
One is for by the college and one is for the government.
My lord, I'm appearing for the.
Then Tuesday.
I'm great.
30 and 31.
30 and 31, ma'am.
Yes.
My lord, I am appearing in 30 only. In 31, my lord, I
My
am
lord, I'm
The
appearing.
same
My
matter.
lord,
Sir.
30 is for against the college and 31 is it was a appeal preferred by the
You are
state
partly there also.
for the state, my lord.
You get wakalatnama for that also. Next.
Much obliged, ma'am.
Serial number 32.
I'm appearing on behalf of the CGST authority. My lord, in this matter, one application has been filed for addition of party, my lord.
My lord, that
my lord-
again and again, my lord, they refer to the
my lord,
intervener.
is
Right of intervention comes after the appellant is heard. Why they are bothered about the intervener and
My
his
lord, there
right?
is a
I don't
direction
understand.
upon my lord.
No. He is not ready today. Hey. Careful. Relax. Sit. Sit for some time.
So
That building, this building problem. That building, this building problem.
your my lord,
What we will do, we will shift,
Please do so.
but distance will be 30 kilometers. We will record your submissions here. ASG is also there.
Code number 1 can never be shifted.
Yes.
No. The entire complex, same problem in Jharkhand. Same problem in
They have
Jharkhand.
shifted and the High Court is
They-
very.
You are, yes. So unless we have that mindset, we cannot. In the next 10 years, this building will be completely choked.
But perhaps the Ranchi High Court building is the best High Court now today in the country.
So Gujarat High Court also, my lord, they have a very huge complex.
My lord, it is a sprawling campus. Jharkhand High Court.
So if you all agree, we can make a proposal.
May I say
My lord,
something?
this area, my lord, it itself, the area itself, my lord, we don't get the parking or anything.
So therefore, the thing is, people a couple of years back said, nobody can go near Salt Lake area. It's all dense forest. People will rob you, no, etc. Now what has happened? It has gone beyond.
Yes, my lord.
So we don't know. It will go into the forest also. This side it is expanding. And now today they say another 3 or 4 more panchayats is also being formed, is expanding. So unless we agree for shifting lock, stock and barrel, So once we shift, all infrastructure will come.
Yes, my lord.
So it will be planned like a judicial township.
Yes, my lord.
And there can be, after a little distance, there can be housing layouts, plots can be sold for lawyers, there can be office complexes, malls, everything will come.
The Bombay High Court also same thing is happening, my lord. They are shifting to BKC. There it will be a judicial complex. So all tribunals, civil court, session court, everything will be in the same premises.
Plus all facilities for the lawyers.
Yes, all facilities
Yes,
for the
office complexes, where you need not have small dingy chambers. Shall I make the proposal?
There in the same premises, my lord, I think everyone will agree.
But this, we will not give it up. This will be utilized for various other purposes.
15 years from now.
Yes, my lord. I think it is a better thing to do.
Probably if you make a proposal now, in the next 10 years, something may
15
happen.
years from now, my lord, he will be there in the, he will take the decisions.
Yes. See, what Lahiri is saying, you will take decisions.
In the committee.
Today he is not ready.
May I start, my lord?
We are also not ready.
My lord, one thing,
Then I cannot
my lord has granted us liberty to file the affidavit in opposition in connection with the addition of party.
Please file.
I am filing, my lord, and your lordship kindly fix the date for here.
And who is the intervener? Where is Mr.
My
Bharat
lord,
Rai Chandani?
We want to serve the.
My lord, I have spoken to Bharat, my lord. I have told him that your chance will come, but let us start. I mean, otherwise, because of you, we are getting stuck.
After Puja, we'll have it.
It will take some time. my lord.
After Puja vacation, my lord.
Yes, my lord, it will take some.
After Puja vacation, my lord, I doubt whether your lordship will be here.
In terms of the liberty granted by order dated 11th of August 2023, affidavit in opposition has been filed to the interveners, to Can 1 of 2023, filed by a third party to intervene in the present proceedings. The said affidavit in opposition is taken on record. Let the matter appear for under the same caption on December 8th.
Grateful, my lord.
Next.
Serial number 33.
I am opposing.
Yes.
On behalf of High Court Administration, I am opposing.
And who appears for the appellant?
The appellant used to appear in person. He was a judicial officer. But he is
But he says he's appearing in person. On the last occasion, did he appear in person?
He used to appear in person, before the Honorable Single Judge at one point of time. Before that, he used to be represented by Mr. Shaunak Bhattacharya.
No.
But he's no more there. He's no more appearing.
Since one of us is not inclined to take up this matter on personal grounds, let this matter released from the list of the records of this case be placed before the Honorable Chief Justice for necessary assignment.
Serial number 34.
I am appearing on behalf of.
High Court Administration. কোথায় opinion কোথায়? His brother. Yes, কি instruction কিছু আছে? কি হবে? নিয়ে সব পক্ষ। Senior citizen. Complaint to Chief Justice of India. They're all unfit, they have to be.
Yes.
I am representing the High Court Administration. This is the last development. I am really sorry. I should have come up with 2 copies. I really forgot to make another copy. My fault.
No, Mr. Gupta is leading me, Mr. Lokhi Gupta, learned senior counsel is leading.
State. No, this I think it's already a matter has become infructuous. No.
I have no instruction, to so submit before your lordships. I will inquire, can we come back immediately after vacation? I'll take detailed instruction. This is the last instruction, that I received, from the administration. Mr. Chatterjee, is my lead.
Yes, sir. What is this, sir?
This concerns, judicial officer, inquiry is pending, but certain orders were passed
No,
by.
inquiry is over.
Yes, that stage the writ petition was filed.
No, inquiry is over. Inquiry report has been drawn. At that stage, where to send the file for some forensic?
Yes.
You contest the DP.
I'm not the writ petitioner. I'm for the High Court administration.
With Mr. Gupta.
My humble submission is this, under Article 311(2), any defense that can be taken on the basis of the evidence already on record.
Correct.
Not something new thing to be recorded.
And actually, if you see the writ petition,
last report.
no, the appeal was disposed of, is it?
No, there's certain direction, my lord.
With the direction upon the Barakpur Police Commissionerate, to conduct a forensic test. But
change.
This was upon modification of the direction passed earlier.
Then Barakpur Commissionerate was changed because he didn't want to do this. He had some acquaintance with him. He didn't do this.
No. Initially, direction upon was the CID. Concerned CID directorate was closely associated with the concerned person, that is why he declined, and therefore the investigation shifted to Barakpur Police Commissionerate. But we are unable to conduct the forensic test since the documents has not been handed over to us.
No, at what stage? What was the writ petition? Let us see the order of the learned single bench.
What is the writ petition? Sir, is a writ petition, Josh, question, what is the writ petition about?
Petition
These were the
pending.
prayers. Writ, sir, it stay application. Writ annex such.
Page 39 is a prayer portion of the writ petition which has been annexed to the stay petition. Page 39. That's the prayer in the writ petition. Impugn departmental proceeding. Quashing the departmental proceeding, that's prayer A. And then consequential orders, all regarding quashing of the
Set
department.
aside the impugned departmental proceedings initiate. So the charge memo is issued, he is given explanation, inquiry conducted.
Inquiry is completed.
Inquiry is complete. Punishment order has been passed?
No.
No. At that stage he has come.
Yes.
And what were the grounds which were raised?
Page 34.
Page 34. The grounds.
Jurisdictional factors, so and so.
This is the main ground. 5. 5 is the main ground. 5 and 7.
Actually, the learned single bench, in its an interim order, I think.
No.
Learned single bench's order.
Yes, learned.
That is
Article
6/12/22.
against the direction of for filing affidavit.
Yes.
Refusing to grant interim order, appeal is from that.
And in that, an direction is
Yes.
issued. And who appears for the appellant?
Mr. Samantu, তাই না?
Surajit
Mr. Surajit Samantu.
Time takes.
None appears for the appellant.
Okay.
We have heard Mr. L.K. Gupta, learned senior advocate, along with Mr. Ranajit Chatterjee for the High Court administration. This intra-court appeal is directed against an interim order dated 6/12/2021, passed in WPA 192/37 of 2021. In the said order, the learned single bench, after hearing the submissions made by the parties, held that there is no scope for passing any interim order, as the court would be slow in interfering with disciplinary proceedings, either at the stage of issuance of charge sheet or even thereafter, till the disciplinary proceedings is brought to a logical conclusion, unless patent illegality is explicit on face of record. Therefore, the learned single bench held, full stop. Further, the learned single bench was of the prima facie opinion that it did not find any such patent illegality at the relevant stage to interfere with the disciplinary proceedings, making it clear that if the appellant writ petitioner ultimately succeeds, he will get all benefits, and such contention all benefits. Further, the court observed that the appellant writ petitioner will also have all the grounds available to him to challenge the inquiry report before the disciplinary authority. Ultimately, the court held that the matter requires to be heard after affording the respondents an opportunity to put forth their stand on affidavit. Full stop. Affidavit in opposition was directed to be filed in 6 weeks from the said date, and reply, if any, to be filed
2 weeks thereafter.
2 weeks thereafter. Liberty was granted to mention for inclusion of the matter in the list for hearing. Agreed by such order, the appellant had preferred this intra-court appeal. In which judgment was rendered on 13/4/2022. Thereafter, interlocutory applications in IA CAN number 2 of 2022 was filed, in which directions were issued from time to time. The sum and substance of the direction issued by the division bench is by directing the High Court administration to send certain records for forensic examination. By referring the matter to the
Commissioner of Police, Barakpur Police Commissioner.
Commissioner of Police, Barakpur. Initially, the direction was to SIFO.
Initially,
but he declined it
refer
for
the
personal
matter
reason.
to the Serious Fraud Investigation Office, Government of India. Subsequently, the order was modified and the matter was directed to be referred to the Commissioner of Police, Barakpur Commissionerate. What is the date of that order, sir?
13th April 2022.
On 13th April
2022.
2022. No, that is the final judgment. No, thereafter it was changed to
On 19th June 2023.
19th June 2023. The question would be as to whether by way of an interim direction, such a reference could be made, more particularly when the writ petition is still pending and affidavits have been called for. In our prime facie view, at this juncture, the question of directing the Commissioner of Police, Barakpur Police Commissionerate, to inquire into the matter will have a serious impact on the decision that is required to to be taken in the writ petition, which is now pending on the file of the learned single bench. In the light of the above, the order and direction issued by the division bench directing the matter to be referred to the Commissioner of Police, Barakpur Police Commissionerate, shall remain stayed until further orders. List the matter on 12th of January 2024. Next.
Serial number 35.
List the matter.
35 and 36. 36. Kindly take it after vacation.
Lord, I appear for the High Court administration.
Kindly, Miller, take it after vacation.
For the High Court administration. But 36 can be disposed of. I tell your Lordship, the writ petition has been disposed of with the consent of the party that these petitioners who are daftaris and Lord, they are seeking Lord appointment in promotional post of record arranger. They will be called as and when the vacancy is announced and Lord, the recruitment process is under.
Recently, one recruitment was concluded.
Yes, recently one concluded, they were unsuccessful. They had filed the writ petition saying that irrespective of the recruitment rules, they should get a chance to.
Sir, I was only seeking one little indulgence of my lords. If it can be taken.
Their appeal, they say item 36 can be disposed of.
I'll just indicate. Lord, while disposing of the writ petition, the order was passed that by consent of parties, they will be called when the next vacancy is declared, and Lord, they will participate in the recruitment process. But Lord, while disposing of the interim application, in the same order sheet, the learned judge says consider their representation. So Lord, if there is a recruitment rules and Lord, by consent the order is passed, your Lordships may kindly have a look at the order. But
Lord, I say, Milord, with the deepest of respect, Milord, there is no recruitment rule. That was, Milord, the issue, Milord, which was canvassed before the learned single judge.
Give item 36.
Lord,
No.
35, my lord, I am appearing for the High Court administration. There is a prayer for taking up the matter on behalf of the appellant for after the vacation.
Yes.
Please pass an order, my lord.
36, one second. 36, we will see. It's an appeal by the High Court administration. Now,
kindly see the order, Lord, impugned order of
yes,
7th
kindly
of
see
July.
that order. Yes.
First, Lord, come to page 3.
The same is disposed of with the as and when vacancy so and so decided to fill up the vacancies, so entitled to apply.
But Lord, the first part of the order, while disposing of the interim application,
Where is
that kindly come back to page 1, where the learned judge deals with can. The direction is at page 2. Page 2, the last paragraph.
directs a representation so and so within a period of 8 weeks? That can't be.
Yes. There can't be blood.
But this direction will be.
Yes. Of course.
That has to be
My
preserved.
appeal is restricted to only this part.
Now, Milord, only one thing your lordship may kindly consider.
We can't have it both ways. No?
No, I say, I was only on the point, Milord, that these persons, Milord, were working as doctories and record arrangers of this honorable court.
No, in your appeal, we will consider that legal issue, whether there is a recruitment rule or not. Now, probably 2 months, 3 months back, recruitment took place and the post of record arranger has been filled up. One thing which subject to what Mr. Carr will say, here the rule is you have to sit for an exam.
Yes.
According to them, merit has to be considered. 50 people are writing the examination. And about let us say there are 10 vacancies. The first 10 score very high marks, but they never get a chance of promotion because the rule says you fill it up as per seniority. Then where is the question of merit? Then it only becomes an eligibility test. Eligibility to compete for a promotional post. If it says merit cum ability, merit alone should be given a priority. This is a very
Milord, I would be submitting very respectfully before my lords that, Milord, if there was a specific rule as to how the particular post has to be filled up, then I cannot make any submissions appropriate. That was the reason they were working for a substantial period of time. What was the direction given by the learned single judge? The learned single judge did not direct that you give appointment or you have to be given reliance. Only thing, consider the representation. Now, consideration of a representation, it doesn't disentangle the person. Milord, from Milord making a prayer.
But then your appeal is for a relief in entirety.
My relief, no, Milord, this subject to correction, Milord, this particular Milord appeal was filed by this honorable court, by the Registrar General of this High Court, Milord, only against this order of 7th of July 2009.
No, the appeal filed by High Court administration
is
against the order dated 7th July 2023.
Yes.
And your appeal, let us see your appeal. That paper.
Did we file it? Milord, subject to correction, Milord, no
What
contra.
is the date of the order against which you have preferred the appeal?
Order?
Milord, the subject to correction, there is no. This is, I think, Milord, this is 35, Milord, the other matter.
35, you are not appearing.
35, I am appearing for the High Court administration.
That's correct, sir. Who is appearing for the appellant?
Mr. Bhattacharya.
I appear, Milord, I say, Milord, that so far this order of 7th of July 2023 is concerned, there is.
No. Then what we will do is we will adjourn item 35.
Yes, my Lord.
I was under the impression.
No, no.
35 and 36 are different matters.
Sorry.
I'm sorry.
At the request of the learned senior advocate appearing for the appellant, you give a date sometime in December. Coming to 36, sir, there cannot be two directions, please. Sir.
Milord, kindly see, Milord, one thing which I very.
কবে ফিক্স হলো?
Please tell you.
Yes, Mr. Bhattacharya.
Yes, Milord.
The first part of the order on CAN.
Yes.
That was on an interlocutory application and order was passed.
Thereafter, this is CAN 3 of 2022. Yes.
Thereafter, the writ petition was disposed of finally.
Yes, because Milord, there is submission
Can the order on an interlocutory application proceed beyond the final decision?
No, I was only submitting.
So it marches with the final order.
I understand.
Final decision was on consent.
No, I say, Milord.
Mr. Bhattacharya, the order passed on the writ petition was on consent. This order was passed.
Yes.
So the earlier part has lost its force with the passing of the order.
No, I was only submitting to my lords. Your lordship may kindly consider that while, Milord, these particular persons, they made representation for considering their case as to whether they are eligible for promotion.
That has been provided. Kindly see the last part of the order on the writ. The same is disposed of with the order that as and when the vacancies to the post of record arrangers are decided to be filled up, the petitioners will be entitled to apply and if found eligible will be considered for promotion. That was your prayer in the representation.
Yes.
In accordance.
Yes.
So initially a direction for consideration. Finally, when the writ petition was disposed of,
both of us, we did not agree with to contest the writ petition. That was the main thing, Milord, for which this order was passed.
Now, as of now,
Milord, single judge asked us that whether we can dispose of. We said yes.
So
now, this is the stand. This is the particular instance. Why the consideration part was made?
that can't be because the writ has been disposed of. And more importantly, sir, as of now, there is no vacancy in the post of recorder arranger. So we are in the process of, on the administrative side, calculating the anticipated vacancy. My suggestion to the committee was that you don't wait till somebody retires. You start the process early. So let us assume 3 months hence, one person is going to retire or 5 people are going to retire. So they are anticipated vacancies.
Yes.
So far as civil judges are concerned, we do that. When we calculate the vacancies, we know that the recruitment process will take 3.5 months, 4 months. So that rule also provides that as on the date when we calculate the vacancy, when we decide to call for application, what are the actual number of vacancies? Anticipated vacancies. And there is also a buffer. In between, there may be resignations.
Yes.
So with that buffer, the High Court administration sends the vacancy position to the government. The government will once again recalculate and then they will send it to the Service Commission. Then the Service Commission will issue the notification, call for applications, start the recruitment process. Honorable judges of the High Court will set the question paper and the question paper will be evaluated by them. Then the results will be published. Then the second stage. Then they get selected civil judges. So here, this exercise I have directed them to do for various posts. Now, as of now, if you see the recruitment section, there are several, even if you ask your clients, they'll tell you it's been going on. Vacancies have been regularly filled up and we are ensuring that there is no stalemate in the matter. So far as Group D and LD is concerned, the vacancies are extremely huge. And High Court cannot conduct recruitment because 50,000 applicants will come. So now we are in the process of getting an agency which does that recruitment. Like some central government organization, state government. Of course, in West Bengal, we don't have a state government recruitment agency except the Service Commission. Bids have been called for. And I think 2 or 3 of them have submitted. And demonstration was conducted before the committee. And everything will be online. They will submit the application. Thereafter, the examination will take. So that exercise is being done. Probably by April 2024. We should be able to have a full complement. That's my estimation.
There I cannot make any comment because I have no I cannot make a comment which does not fit me to make a comment.
No, not that.
No, I say, Millard, this I should be very, Millard, candidly submit, make this submission.
No, we will preserve this direction. And once again, this vacancy position is being recalculated. And they may also be eligible for other posts in the same cadre as record assistants. So, but this rule is, I am not very convinced.
I say, Millard, this is that was the issue.
I tell your lordship, if you, my lord, kindly takes page 150, kindly give you 154.
Yes.
This is the Recruitment and Promotion Committee's
resolution.
Resolution. Please turn to page 155.
Yes.
This is how this has been. The modalities are this. It's merit cum seniority. That's the
problem.
First merit, and then obviously.
See, the youngsters, as a result, they get frustrated. See, if assuming 100 marks, these fellows are able to score 85, 90. But the minimum pass mark is 40. By virtue of seniority, that person gets it. And this fellow is languishing. And he says, I've been preparing for the exam, I did well. Obviously, the age factor is also there.
Age is the most important. Your lordship may kindly consider, my lord, while your lordship is discharging the administrative functions, lordship may kindly consider that these persons who are, my lord, have nothing to do because of their age and because of the particular process.
My understanding of the recruitment rules is that Lord, once people qualify in the written exams, they come under the zone of
Consideration. Correct.
Then Lord, the seniority is applied thereafter. So my lord, merit is the first issue. They have
Therefore, merit does not actually weigh for the purpose of promotion. Merit is only as an entry point.
I am grateful to my lords. I am grateful to my lords. Because
that is their grievance.
I am grateful. And my lord, what I submit, my lord, that if this particular criteria is being adopted or is applied, all persons in my lord's administrative side, my lord, they will never, my lord, be eligible. They will never be.
I understand.
They will never be.
My learned friend's grievance in the writ petition was otherwise. They didn't want to sit for the exams. They were saying that previously, prior to this resolution being adopted, previously, there was a panel prepared based on seniority, etc. And they wanted that to be followed.
That can't be done.
This is their writ petition.
That can't be done.
That
in the present circumstances, even the lowermost cadre post, pan India, it is through competitive. We can never now revert back to original. Then discretion of the Chief Justice. Nothing can be done. After Supreme Court decision, Justice Chavan, Justice Iqbal decision, nothing can be done. This is the only method to be followed. So we have to be rest content that the question of preparing panel, pick and choose, put this fellow on top, pull this fellow on bottom, nothing can be done. That is why everything is uploaded.
Yes.
This intra-court appeal by the High Court administration.
Kindly give some latitude to these persons. I appeal to my lords. I do not say.
No, I am working on.
I say I have nothing to say.
I am very seriously working on it.
No, I am grateful to my lords.
This intra-court appeal by the High Court administration is directed against the order dated 7/7/2023 in Can 3 of 2022 in WPA 438 of 2020. The appellant is aggrieved by the order and direction issued by the learned single bench while disposing of Can 3 of 2022, by which the representation dated 16th August 2022 was directed to be disposed of by the Registrar General within a time frame. In our view, such a direction could not have been given as the writ petition itself has been disposed of with the consent of parties by observing that as and when vacancies to the post of record arrangers are decided to be filled up, the writ petitioners will be entitled to apply and if found eligible will be considered for promotion in accordance with law. Thus, any order passed in an interlocutory application cannot survive beyond the cannot operate on and after the writ petition itself has been disposed of. Furthermore, in the instant case, we find the direction issued in Can 3 of 2022, in fact, exceeds the directions issued in the writ petition, namely WPA 438 of 2020. Therefore, the appeal filed by the High Court administration is allowed, and the direction issued in Can 3 of 2022 dated 7/7/23 is set aside. The direction issued in the writ petition is affirmed, which is to the effect that as and when vacancies to the post of record arrangers are decided to be filled up by the High Court administration, the respondent writ petitioners will be entitled to apply and if found eligible will be considered for promotion in accordance with the relevant law. Allowed with the above observation. Yes. Next.
Serial number 37.
Your lordship has disposed of the appeal.
Yes. 37.
This is, my lord, covered by your lordship's recent pronouncement, my lord.
Who will appear for the High Court administration?
High Court, my lord, Mr. Ranjoy Dey is appearing.
He is not here today.
It's been served. Ranjoy Dey ka phone call.
we'll give him some time. It is submitted that Mr. Ranjoy De has been nominated, was appeared for the High Court, respondent High Court administration in the writ petition. The learned advocate appearing for the appellant is directed to serve one set of papers on Mr. Ranjoy De, and he is requested to appear in this.
Papers already served, and I'll serve a notice. I think if I
Serve
call
notice
him, my
on
lord, he
Mr.
will.
Ranjoy De, learned advocate for the respondents, who shall appear for the respondents. And such appearance may be regular.
It's only, my lord, the post is supposed to be filled up. There is an apprehension recorded.
Nothing will happen. Happy Puja. Next.
Lordship has kept it after pujas.
Yes, obviously.
This is covered by your lordship's judgment, my lord.
Wait, sir. Nothing. Heavens won't fall. Next.
Serial number 38.
Yes. So, but if in the meantime, if the post is filled up, my lord, this is, well, as 2 + 2 4 matter, my lord. It's nothing.
2 + 2 4. Let the single bench decide. Or we can advance the writ petition. Will you be satisfied?
Advance. Well, I'll let me place it before a lordship first.
Not before vacation.
It's not before vacation. Yes,
but before, what we can do is we can dispose of the appeal so that we can direct the High Court administration to file.
I think, my lord, this is such a, my lord, matter. But after your lordship's judgment, my lord, I think your lordship, my lord, writ petition can be allowed from here itself.
Already,
there were two posts. One post, my lord, reserve general category candidate has not been filled up. The other post, my lord, the meritorious candidate in reserve category has been filled up. I am the lesser meritorious. She has to be shifted there, and I'll see.
Yes. Next.
Serial number 38.
My lord, this is an appeal against the order of the West Bengal Taxation Tribunal.
What was impugned before the tribunal?
Yes, ma'am. My lord, before that, may I in brief narrate the facts of the case which led to my going to the tribunal? What were my grievances before the tribunal and why I am aggrieved with the order of the tribunal? Now, my lord, the petitioner is a registered dealer under the West Bengal Value Added Tax. My lord, he is a manufacturer of ferromanganese and ferrosilica products for which he uses coal and coke as raw materials.
Coal and coke.
Coke as raw materials. Now, my lord, he was selected for audit under Section 43 of the West Bengal Value Added Tax Act. Now, my lord, in that proceedings, my lord, an audit proceedings under 43(5)(a) becomes an assessment order under Section 46(1) of the VAT Act. Now, my lord, in that he appeared, he produced his documents, and my lord, there is a provision that is, my lord, which says that before passing, yes, Rule 57, provision to Rule 57(4). My lord, it says that before passing, it says no order of assessment will be passed unless a draft of the order containing a gist of the adverse findings is given to the dealer, and he is given 7 days time to rebut to this. My lord, this is somewhat similar to Section 144C of the Income Tax Act, where also a gist of the order has to be given. Now, my lord, he appeared, they examined his documents, and he passed a draft assessment order containing certain adverse findings. Now, my lord, the petitioner had claimed, my lord, 96 lakhs of rupees and as ITC. In that, my lord, the adverse finding was only 2 lakhs of rupees is disallowed for various reasons, and he submitted his reply. My lord, when the final order came, my lord, about 21 lakhs of rupees of ITC was disallowed, which was allowed in the draft assessment order. And as a result, my lord, his in the draft assessment order
went beyond the scope of the drafters.
Yes, beyond the scope of the draft order. Now, my lord, and as a result, what happened? It was added to his tax liability. His tax liability, which was something like 2 lakhs and odd, became 32 lakhs, more than that. Now, my lord, the petitioner, my lord, filed his statutory appeal under Section 84. And my lord, Rule 138 to IA and capital A, my lord, states that for filing an appeal, you have to pay 15% of the tax in dispute provided, my lord, the gist of the adverse order is conveyed to you. My lord, he paid 15% of tax in dispute on that portion of the final assessment order in respect of which adverse findings were given. But for the 22 lakhs which was disallowed and which was beyond the scope of the draft assessment order, my lord, he did not pay 15% of tax in dispute and he invoked this provision. My lord, the appellate authority, that is the respondent number 2, my lord, he rejected.
So he dismissed it on the ground, pre-deposit not affected.
Pre-deposit not given, my lord. My lord, against this, my lord, I went before the taxation tribunal. My lord, my grievances before the taxation tribunal were twofold.
That was a revision.
No, my lord, this is not a revision, my lord, because it is arbitrary. So it is akin to the writ jurisdiction.
Okay.
My lord. So tribunal has that power. Extraordinary jurisdiction, my lord. So, my lord, I submitted, my
And
lord.
what happened in the tribunal?
My lord, tribunal, what the tribunal did, instead of passing any order whether my appeal can be entertained, because I had paid 15% of tax in dispute, tribunal set aside everything, even the draft assessment order, and said he will start issuing it from the draft assessment order. My lord, I am aggrieved with that portion of the order because, my lord.
Now we can do one thing. There is a draft assessment order, objection given.
Yes, my lord.
The final order passed was beyond, according to you, beyond the proposal in the draft assessment.
Yes.
So that final order should go.
Yes, my lord.
But if according to the authority, there was a mistake while drawing up the draft assessment order, are they not entitled to rectify that mistake?
My lord,
Suppose, let us say, while preparing the draft assessment order, the authority came to a conclusion.
Yes.
What is the amount of ITC to be disallowed? 2.5 lakhs.
Yes, my lord.
You give in your objection, records everything. He scrutinizes, then he finds another 15 lakhs has to be disallowed.
Yes.
So can he not exercise jurisdiction at that stage?
My lord.
Unless it is barred by time.
Yes, my lord. My respectful submission in this matter, my lord, before the tribunal, I relied upon a judgment which is in respect of 144C of the income tax authorities. That is, my lord, Turner International India Private Limited versus Deputy Commissioner. My lord, here, what happened? Your lordship is well aware, my lord, of the case of Zuari Cement, where, my lord, no draft assessment order was given, and it was held that the final order was null and void without jurisdiction.
This income tax, this is actually international taxation. International taxation.
Yes, transfer pricing.
Transfer pricing. There is a separate chapter by itself. It is a standalone. In fact, and the Income Tax Act itself, it's a standalone provision which provides for a draft assessment. Otherwise, it's not a normal rule. But under the VAT Act, which is the provision which draws up the...
Yes, my lord. My lord, regarding issuance of a draft assessment order. Yes, my lord. My lord, Rule 57, proviso to Rule 57. Yes, my lord, I'm giving.
Rule 57.
Proviso, my lord, page 504, my lord. My lord, page 504 of Mundra's book, my lord.
Yes.
My lord, it says, my lord, the proviso, provided that no order of assessment shall be passed under subsection 1 of section 46, where the total amount of demand of tax exceeds rupees 20,000 upon such assessment, unless the dealer is given a gist of the proposed order containing the adverse findings which may result in such demand of tax, and an opportunity is given to the dealer to rebut within 7 days of such adverse findings and to produce supporting documents wherever necessary. Now, my lord, my submission, respectful submission before your lordship.
You want to keep the draft assessment order
intact. And let it be, my lord, carried forward, my lord. Let the adjudicating appellate authority decide. But my appeal, my lord, I have paid for the balance amount, my lord, I have paid 15%, 1 lakh something. My lord, my appeal to be admitted. And my lord, the tribunal agreed with the judgment of Turner International. But while disposing it of, my lord, he set aside the draft assessment order and said fresh draft assessment order is to be issued. Now, my lord, I have produced all my books of accounts before the draft was passed. He has formed an opinion. So, my lord, it is my respectful submission that the draft should not be...
Unless and until you are able to show there is a statutory bar on the part of the assessing authority to have, revise the audit report.
Ma'am, my lord, here my first submission.
How
would
do
be-
you say it becomes any, first of all, this ITC itself is a concession.
Yes, my lord.
Suppose you don't fall under any of the clauses, subsection 2, I think, you are not entitled for the credit. So later on they discover, no, it should not be X, it should be X plus 1.
My lord,
They can draw up a fresh and
my lord,
the assessee will have full opportunity.
what I'm submitting, my lord. I'm not submitting, my lord, at this stage that it should not be taken as it, since your lordship is of this opinion. Let my appeal be considered and let the appellate authority decide, because I am I'm appearing before him. So he can also decide that whether it would be allowed or not allowed, my lord.
Then the matter has traveled up to the tribunal at your instance.
Yes, my lord.
You invoke 226 or
But the extraordinary jurisdiction.
And now to send it back to the appellate authority is futile exercise.
Because, my lord, he did not even consider my grievance submissions that my appeal may be accepted in respect without paying 15% of the tax in dispute in respect of
In fact, you have succeeded before the tribunal.
But, my lord, if what would happen to me, my lord? The next man come and even broaden my.
No, the next man will can even drop the proceedings.
My lord.
Think on those sides.
My lord, but then what would happen, my lord? It would also set up a bad precedent where no order is passed, draft assessment order is passed.
That is why rightly the tribunal set aside the entire matter and directed the first respondent to issue a fresh audit report from the stage of draft report.
My lord, he may consider it from the stage of the final assessment order. Let him consider there. Another second thing, my lord, it is my submission, my lord. Your lordship may kindly consider this, my lord.
But then.
My lord, let my appeal be heard.
But now what to do? You can't set the clock back. Now the tribunal has given some finding on your petition.
My lord, I will only show, my lord, what the tribunal has said. My lord, kindly can't see this, my lord. My lord, I know that my appeal was not. My lord, kindly see what the tribunal has stated. In fact, where the tribunal erred, my lord. That, page 87, 89, my lord. Page 89. Nari Baba. 86. I'm tribunal order. 89 and again. 87. Where he says that I have considered that. Yes, my lord.
But if unless you put up the 15% pre-deposit for the entire amount,
my lord,
the appellate authority cannot entertain the appeal. There is a statutory bar for it.
But, my lord, it says under rule, my lord, 128, my lord, I'm predicting rule 128, 1A, 138, 1A, my lord.
That is page number.
My lord, 138, 2.
608.
My lord, page 608, 138, 2, IA, A. My lord, it says, where such an appeal is filed on or after the first day of April 2015 in respect of an order of assessment other than a provisional assessment under section 45 made on after the first day of April 2015, and where such order has been passed upon communication of adverse findings in accordance with the provision to sub-rule 7 of Rule 54 or to sub-rule 3 of Rule 57 as the case may be, then, my lord, an amount of 15% after capital B of the amount of tax in dispute in such appeal has been paid.
So now, let us see the final assessment order.
Yes, my lord. My lord, fine. My lord, page 53. Yes, my lord. But the relevant portion is page 57. Yes, which is contradictory to the draft assessment order, my lord, at page 48. My lord, kindly see page 48 where the draft assessment order, what was taken there. Page 48. It was, my lord, ITC allowed for the year is 94,32,813. And my lord, he has, after checking, my lord, before that, ITC to be adjusted with output tax. The dealer has claimed an ITC of rupees such and such, of which 94,32,813 is found allowable. After checking the original tax invoices related to purchase with the purchase statement, bank statement, ledger accounts, etc. provided by the dealer, rupees 2,27,308 is disallowable as discussed above. My lord, he has checked. That is, my lord, page 48. My lord, then kindly come to page 57. No, ITC to be adjusted.
But in page 57.
Yes, my lord,
or
kindly.
Page 48.
Yes.
This issue, whether the dealer has used coal and coke as fuel. That issue was not considered.
No, he did not, because I had produced, he was satisfied.
Therefore, if you want your appeal to be considered, subject to what the government pleader says, you pay 15% of the total amount due as computed in page 58.
Page 58.
Page 58.
That is, my lord, I have to pay on the balance.
Yes, it's still worth it.
But my lord, what the rule 128 says only, on 138 says only.
Therefore, as of now, you treat this as a disputed amount of tax. According to you, 227,308 alone was in dispute. 2,27,308.
Yes.
Page 48.
Yes, ma'am.
Correct. That was alone in dispute.
That is, my lord, the 12,20,000 which was disallowed, my lord, in the final assessment order. It came to, my lord, page 57. My lord, it was reduced to 73,98,623 and 12 lakhs was disallowed.
So on that 12 lakhs, you pay 15%.
My lord, but that was my grievance before it, my lord, that your lordship lay down the whether how this.
Either we confirm that or subject to what government pleader may say, if you pay up 15% of the entire tax in dispute as per the final assessment order at page number 53.
No, in that event, my lord,
it's still worth. It's still worth. You can still argue before him that the draft assessment order should remain intact.
Should remain intact.
That to the 15%, I don't have any problems. That is the law, because under section 84, also section 84 says the same thing.
The legal issue is preserved.
All right.
The draft
contention is,
but the draft report, that part, the authority, I think
they have got power.
Powers are there, and that is what the tribunal has held. So I must say that there is nothing wrong with this order.
The nature of use of that raw material was not gone into in the draft assessment order. In the final assessment order, after seeing your papers and your reply, he found that this raw material has been used as fuel. Therefore, you are not entitled for credit. You need to attack that finding on merits. So, for the present, if you are agreeable in the entire disputed tax, because if you see the order passed by the appellate authority, where is that? Just now I saw.
Wait.
Page number 73. Not 73. This is form of appeal.
Page 71.
Where is the appellate authority's order?
71.
70.
Page 71.
Page 84. Correct?
Yes. My lord, there was a revision, my lord, revisional order.
Oh, revision. So you filed appeal, you filed revision, you went to tribunal, and now you have come here.
Yes.
Then in that event, my lord.
And they won.
Yes.
My lord, my lord, in that event, as it fell from your.
Whether a challenge is maintainable. Lordship's query is whether challenge is maintainable.
That is what, because
you succeeded.
I thought I would have been.
My lord, in that event, my lord, let it fell from the tribunal, let it go through because he has the documents to show that it has been used as raw material, my lord. But meanwhile, my lord, I have paid 1 lakh something, my lord, as a pre-deposit for filing the appeal. What would happen to it?
That will abide by the result of the fresh proceedings to be conducted.
That is
No. That will be because any adverse order
So
is.
that can be refunded.
Yes, my lord, that may be refunded. My lord.
Refunded and recredited to your.
My lord, and let it be start from the original, again, draft assessment as it.
That is the order.
No, but that amount
No,
paid as 15%.
Deposit of
Yes, well, that
will
will
be
also
refunded.
subject to, yes.
That may be refunded to me, madam. I'm grateful.
This appeal filed by the SSC is directed against an order passed by the
15%. But the 15% deposit stays.
My lord, I have paid it for that portion of the order against which there was an adverse finding. It is already I paid in appeal.
Yes, 1,61,000.
1,61,000.
If you see
the entire amount I did not pay.
So, my lord, your lordships are holding on the 15% of the assessment tax assessed.
No, they have paid 1,62,031.
Yes, my lord.
Now the tribunal has set aside all the orders.
Yes, my lord.
Therefore, this amount of 1,62,000 may be refunded to
Yes,
them
ma'am.
or recredited to their cash ledger.
My lord, there's no cash ledger. It may be refunded, my lord, and we will start from the original. Let him issue a
Or
draft.
it can be adjusted against your tax dues. It can be adjusted against the future.
But that is that because
That's
the refund
better.
may not be
Refund
possible.
is next to impossible, madam. You know better. Next to impossible. They will never give a single pie.
My lord,
Now,
so
contempt petition we have issued notice that other matter.
my lord, you let him start.
Get payments, well,
Let him start from the draft. Tribunal remained silent, did not say anything about that 1 lakh.
This writ petition has been filed, challenging the order passed by the West Bengal Taxation Tribunal. In an application filed by the appellant writ petitioner assessee, challenging the orders passed by the revisional authority as well as the appellate authority. Affirming the appellate authority. The decision taken by the appellate authority was not on merits, as the appeal was dismissed on the ground that 15% of the disputed tax has not been pre-deposited as required under Rule 138 of the West Bengal Value Added Tax Rules 2005.
Read with section 84, Marat. And that is the section
84 of the West Bengal Value Added Tax Act, read with Rule 138 of the West Bengal Value Added Tax Rules 2005. This order was affirmed by the revisional authority. The writ petitioner invoked the extraordinary jurisdiction of the tribunal by challenging the order of rejection of the appeal on the ground of non-deposit of 15% of the disputed tax, by contending that there is a gross discrepancy in the final assessment order when compared with the draft assessment order, where there was only a proposal to disallow rupees 22,730,8, which was availed as input tax credit by the writ petitioner. While passing the final assessment order, the disallowance was more than rupees 12 lakhs. Therefore, the writ petitioner contended that the pre-deposit of 15% should be calculated on the disallowance which was proposed in the draft assessment order and not what was disallowed in the final assessment order, as the writ petitioner had no opportunity to put forth their objections against such disallowance, and this will be in clear infraction of the proviso in Rule 57 of the rules.
57(4). 50, proviso 57.
Proviso 54.
3. 57(3).
No.
3. Proviso to rule sub-rule 3 of Rule 57.
57.
57, page 504.
In our considered view, these issues need not be gone into in the light of the fact that the writ petitioner had succeeded before the tribunal, as the tribunal came to the conclusion that there are several infirmities in the order passed by the revisional authority, and the original authority also has not considered the entire case. No, the various contentions raised by the writ petitioner. Therefore, the tribunal thought fit to set aside the draft and the final audit report and directed the first respondent to issue a fresh audit report from the stage of draft report. In our view, the learned tribunal had rightly relegated the matter back to stage 1, by stage 1 by directing the concerned authority to draw a fresh audit report from the stage of draft report. Further, we find that the order and direction issued by the tribunal sufficiently safeguards the interest of the appellant, giving liberty to interest of the writ petitioner, giving liberty to the writ petitioner to canvass all points as and when a draft audit report / draft assessment order is drawn and served on the appellant. Therefore, we find no grounds to interfere with the order passed by the tribunal. It is submitted by the learned advocate for the petitioner that while filing the appeal before the appellate authority, the writ petitioner had effected a pre-deposit of rupees 161. 161.
Yes.
Oh, sorry, 162,031.
Yes.
And this
152,031.
1,52,031. 031, and submits that this amount may be directed to be refunded. In the light of the orders passed by the tribunal, remanding the matter back to the first respondent to commence from the stage of the draft audit report, the amount which has been pre-deposited by the writ petitioner, namely rupees 162,031, shall be adjusted against future tax liabilities of the writ petitioner. With the above observation, dismissed. Yes.
I'm very grateful.
Next.
Serial number 39 and 40.
No, last occasion we said that both the volumes of the stay petition should be made available. Still, it is not there.
It is later we had checked. It was there in the file, my lord.
In the second here, what I've got is I have got volume 1.
Yes, my lord.
And there is volume 2.
আপনার অন্যটাতে নেই মানে খালি
We have got FMA 340.
My lord, I've just been
No, you
informed
pick up there.
that this has been given.
There are two appeals.
40 and 342.
What is this? 342, both sets are there. (342), there is only one volume.
Yes.
340, there are two volumes. Volume 2 is missing in my file. Volume 1 is missing in his lordship file.
No, we have only specifically checked from your lordship's office. It was there, my lord. My junior is also there, my lord.
Where it went off?
We were in, my lord, anyway, let us take it on another day.
No, we'll direct the department to put up.
Or may I hand over one copy, my lord, if it is not.
I don't know. You have to take a fresh photocopy, waste of money. We'll check in the department.
Otherwise, normally,
They will not
filing won't be completed without both the copies.
Number won't be assigned.
My lord.
Probably they put it up in some other file. All right.
My lord, then take
472. 472.
In FMA 340 of 2023, the one of the volumes of the stay petition is not forming.
My lord, probably the petition, my lord, is also wrong, because what I have here,
472.
the number is 472, Matt, 472 and 473.
473. In 473.
My lord has 473. In 473, my lord has only one set. In 472, my lord has both sets.
There is only one set in 4. There is no 2 volumes in the other one. Correct.
Now, in the other matter,
Only one volume is.
no.
Only one volume.
Only one volume, no?
In one matter, only one volume.
In 473, there are 2 volumes.
2 volumes. In 473, there are 2 volumes.
When you say the department is directed to put up both the volumes of the stay petition in MAT 473 of 2023. In the event the same is not available in the department, the learned advocate may be for the appellant may be intimated so that a fresh set can be filed. Next week.
My lord, next week. Data, please. And I have also served the other side again, consequent to my lord's directions on the last occasion.
And who will appear?
My lord, Mr. Siddiqui was appearing that day. But he is in court 10, my lord. And that's okay. Any matter is not being taken up today. Next
week.
My lord, I will
please inform.
Definitely.
Next.
Serial number 41.
Nam
41.
I'm for the respondent in this matter. So I'm appearing on behalf of the appellants.
Deficit court fee has been.
Yes, your lordship, it has been paid, your lordship.
What is the matter?
Lordship, show cause was issued. The matter was before your lordship, you have challenged the order of the adjudicating authority. But the adjudicating order has been upheld by the
No, your friend is come.
My lord, now they are challenging the adjudicating authority order. How it can be? Your lordship.
Because there is no other way. They have missed the bus.
But they have missed the bus. Sir, if your lordship pass the order, then it will open a floodgate, my lord. It is my humble submission. Everybody can take this opportunity that when we have
but that person didn't contest that component, no? He contested only the penalty.
Only main is not they have challenged.
Should they not be given one opportunity?
My lord, your lordship can your lordship can direct them to deposit the entire amount and direct the.
No, 20% only is the pre-deposit before the tribunal.
Only that to the penalty amount. But to the
normally,
yes, my lord.
20%.
Only 20.
So now, as against, where is the adjudication order?
Yes, but the adjudication order is at page 80.
So against this order, he can file an appeal to the commissioner.
Yes.
They did not prefer. But you preferred an appeal to the commissioner.
We preferred
and penalty got enhanced.
Penalty got enhanced.
Against which they are before the tribunal.
They have not gone.
No, they have gone.
No, they have not gone.
Even that was also not challenged, but straight away this writ petition was filed, alleging that there has been a violation of the principles of natural justice because the documents were not given.
And
to
in this, you have challenged the
both
adjudication order, penalty, enhancement of penalty,
and enhancement of penalty. Solely on one ground that there has been a violation of the principles of natural justice because the documents which were seized from me were not given to me. But not be that as it may, I'm in your lordship's hands.
And what is the amount which was computed as service tax liability?
The service tax liability is 33,50,003, and on that is the enhanced penalty of. The enhanced penalty quantum of penalty to 38 lakhs.
Subject to what Mr. Maiti says, you pay 50% of this 33 lakhs. We'll give you liberty to go to the commissioner.
Madam. As a lordship pleases, but I can't quarrel in this.
No, 2017, you passed this order, you framed the order and kept in your office. What you are able to get, one single pie you are not able to recover.
Only pray I can pray before your lordship. This will not create a precedent
Yeah,
by any
obviously.
other. My lord, that.
And he is, what is the nature of business?
Nature of business construction.
Construction.
Big.
No, my lord, not now. Now it's not running. For the last 3-4 years, my lord, I'm told the business has stopped.
This intra-court appeal by the writ petitioner is directed against the order dated 6/6/2023 in WPA 8929 of 2023. In the said writ petition, the appellant had challenged the order of adjudication passed by the Assistant Commissioner Service Tax, West Division, Service Tax number 4 Roman 2 Commissionerate, Kolkata, dated 21/6/2017, by which the adjudicating authority confirmed the demand of service tax of rupees 39,93,475 as proposed in the show cause notice. And after appropriating the amount which was deposited by the appellant, the remaining amount of rupees 33,50,003 was demanded. By the same order, penalty equivalent penalty of rupees 33,93,956 was levied. As against the order of adjudication, the appellant had an effective alternate remedy of filing an appeal before the Commissioner of Central Excise Kolkata. However, the appellant did not prefer such an appeal. On the contrary, the department preferred an appeal on the ground that penalty equivalent to that of the service tax liability ought to have been imposed. It appears that the appellant did not appear for the personal hearing on the 4 dates which were fixed. However, subsequently sought for adjournment, which request was rejected by the Commissioner, and the appeal filed by the department was allowed, and the penalty was enhanced to rupees 38,93,956. Though such order 956 by order dated 2/11/2018. Though the adjudication order was passed in the year 2017 and the enhanced penalty order was passed in the year 2018, both orders till date remain as paper orders, and the respondent department has not been able to recover any money from the appellant. In this writ petition, what was the reason which you said you didn't do it?
Because when the search and seizure operations were conducted, my bills, work orders, and profit and loss accounts were taken by the officers. Though I did not keep any original. I didn't have any photocopy, and I could not disclose it before the authorities.
In the writ petition,
My lord, your lordship will kindly that see page 71, para 2.5. Page 71.
What is that?
Para 2.5. Documents, records, profit and loss account, bills of invoices seized or submitted by the said assessee for the period, relevant documents enclosed for RUD4. So that has been given to him in the so cause notice.
All right. In the writ petition, the appellant contended that several documents were seized, and the appellant had requested the department to return the documents so as to enable them to effectively contest the proceedings. Certain other reasons were also set out in the writ petition. As rightly pointed out by the learned senior standing counsel for the respondent department, the reason for not preferring an appeal or challenging the order of adjudication as submitted by the appellant in the writ petition are far from being satisfactory. However, we find that as pointed out above, though the adjudication order was passed in the year 2017, till date, the respondent department has not been able to effect any recovery from the appellant, and the orders of adjudication have remained only on paper. Thus, balancing the interest of both parties, more particularly bearing in mind the interest of revenue, we find the case on hand to be a peculiar case where certain directions can be issued so that part of the amount payable by the appellant can be recovered by the department. Simultaneously, the appellant can also be granted an opportunity to question the correctness of the order of adjudication. So, as well as also put in the make their submissions as to whether the penalty imposed by the department, penalty enhanced by the commissioner was warranted. In the light of the above, the appeal stands disposed of by directing the appellant to deposit 50 to pay 50% of the sales of the service tax, which was determined and demanded in the order of adjudication dated 21/6/2017. Such payment shall be effected by the appellant within 6 weeks from the date of receipt of the server copy of this order. If the appellant complies with this direction, the appellant is granted liberty to file an appeal before the Commission of Central Excise (Appeals) Kolkata within 30 days thereafter. That is 30 days from the date on which the payment is effected by the appellant. And in the said appeal, the appellant is entitled to canvass all grounds as to the correctness of the order of adjudication dated 21/6/2017, and the appellant shall also be entitled to contest the levy of penalty as well. Since the appellate authority, namely the Commission of Central Excise, while passing the order dated 2/11/2018, had rejected the request made by the appellant for an adjournment and proceeded to take an ex parte decision, the Commission Appeals shall permit the appellant to canvass grounds as regards the levy of penalty as well as the quantum of penalty leviable. Thus, full stop. All legal issues are left open to be raised before the appellate authority, namely the Commission of Central Excise (Appeals). As pointed out earlier, this order has been passed considering the peculiar facts and circumstances of the case and shall not be treated as a precedent. Next.
So grateful.
Serial number 42.
Yes, sir. Serial 42.
Before my learned friend starts, but I generally don't do this, but I have a preliminary objection,
Preliminary objection.
Yes, because on the maintainability of the appeal, because your lordship knows, unless aggrieved, an appeal is not maintainable from a writ petition, and there is an appeal from an interim order refusal. Now, I would like to show your lordship only 2 documents.
No, this appeal.
No, allow me to submit your.
No, I've taken a.
Allow us to submit also.
Yes, your lordship.
No, Mr. Saraf's technique is he files the intra-court appeal and he will say, try to draw us to decide the main matter.
May I just say this, your lordship?
He will say, I am dead. my client is dead.
I understand it.
My registration cancel. See this point, only this short point.
Malad, that is the point.
That
but
is the
Malad,
modus operandi.
yes, but I know
That
that.
is the
Malad.
purpose of this appeal.
But today, Malad, I would like to take heed to his writ petition to say he can't do that. Malad kindly takes the writ petition. If this is allowed, Malad, henceforth, Malad, then we cannot. Malad kindly take 62, page 62, Malad.
No, we can drag the writ petition also.
If your lordship wants to, then Malad, may I just say this?
And
I
on
was,
what ground is registration? You will hear. We'll hear, Mr. Shara. Why your registration was cancelled?
My lord, the registration was cancelled on the ground, my lord. There are three
Forged
grounds.
the rent agreement,
Forged
electricity bill,
rent agreement,
you never
electricity
existed.
bill, and non-existence of the supply. Now, my lord, the entire exercise, let me point out, my lord, what happened, that these all the directors of these companies, they are not from West Bengal. They are from Kanpur and Delhi. Now, my lord, they are in the business of one, gold bullion, and number two, my lord, the MS pellets. And the entire business operation is carried out in a bill to ship to model, my lord. I'll show the documents I have.
They are into gold and steel.
Gold and steel, gold bullion,
and all
trading, trading of gold bullion and MS billets on a bill to ship to model, my lord. And my lord, once the proposal was done to cancel the registration on this ground, so they, in the reply, they pointed out that they had appointed one person to look after the local affair, one Pran Gopal Saha, who happened to be the son of the landlady who was holding these premises. Now, what this person did, that he was in possession of a electricity bill of a dead person who was also residing in the same premises. Probably he was a tenant, elsewhile tenant. He died in 2015. And since they engaged in the COVID period, he said that in order to make some quick money, so he did not want to tell his mother that I am giving this sort of a, my lord, the premises where actually there is no business operation required to be carried out, but the registration is required only for the, my lord, registration purpose. That address is required. So he took advantage and he provided the electricity bill of not his mother, but of that person who is dead. But my lord, before my registration is cancelled out, once I have pointed out in my reply that this person bluffed me and he dragged me into getting the registration. My lord, he could have chosen to give me the electricity bill of his mother also, which we have annexed with the writ petition. The municipal receipt in the name of his mother as the owner of the property, we have also annexed. But the authority, before cancelling the registration, my lord, did not bother to make any inquiry with this person whom we are alleging that on his, and we gave the bank statement also that we have made payment to him in lieu of this getting us this premises for registration. And my lord, they interviewed some other person, one Ayan Saha, who happens to be the cousin brother of this person. And maybe there is some, my lord, as it happens in families, they have some rivalry. So he said that this person does not. Obviously, he does not know. Even if he has not told his mother that I've given these premises for.
No, you could have done one thing. After you had come to know that this Pran Gopal Saha and the son of the landlord who did some mischief, according to you, you could have regularized that by going to the landlord and saying that, Madam, now you give a letter to me, let me go to the department and say that I am a tenant in this particular place. Because
the thing is
what the appellate authority says is that the level of unawareness on the part of the taxpayer is not convincing. That's the reason he is given. All this cock and bull story, who will believe? Kanpur is not in South Africa.
My lord, what I am submitting is, your lordship,
and
that my lord,
dealing in gold, bullion.
My lord, what I am submitting, your lordship, is that they chosen to inquire somebody who is not
apply for a fresh registration now.
No, my lord, what I am submitting, what I'm submitting, your lordship, is that he can go for the fresh registration. Now, my lord, there are judgments of the Delhi High Court also that there is no proposal in the notice for retrospective cancellation. So they have.
That is why the learned judges call for affidavit. We will direct them to file the affidavit within a week. Probably on the reopening day, we will direct the matter to be listed in the single bench list, and it will be taken up.
my lord, your lordship had earlier made several such direction. Those matters are not taken up. If your lordship gives a
You
specific,
have to mention to the learned.
no, I mentioned, my lord, but so, my lord, if your lordship gives direction, a specific direction, I have no problem. My lord.
This intra-court appeal by the writ petitioner.
May I only make one small section and just keeps it 1 week after vacation.
Yes.
Very
This intra-court appeal by the writ petitioner is directed against the order dated 5/7/2023 in WPA 143/58 of 23, in and by which the learned single bench declined to grant any interim orders but directed affidavits to be after elaborately hearing Mr. Vinay Sharaf, learned advocate appearing for the appellant, and the learned ground pleader appearing for the respondent state, we are of the view that the learned single bench was right in refusing to grant an interim order, since if any interim order is granted, the effect of which would be allowing the writ petition itself at an interlocutory stage, which is impermissible. The learned, we have full stop. We take note of the submissions of the learned counsel for the appellant that on account of retrospective cancellation of the registration of the appellant is put to great prejudice, and the clients of the appellant are also now being issued notices, which is causing lot of hindrance in the business activities. Thus, considering the said submissions, we direct the respondents to file their affidavit in opposition by 22nd November 2023. Reply, if any, within you want to file a reply? All right.
Lord, 1 week time.
Reply if any within 1/12/2023. Let the matter be listed before the Honorable Single Bench in a reachable position on 4/12/2020.
4/12. Grateful. Grateful, lordship. Grateful.
Thank you. You mentioned the matter in the morning, matter is displayed.
Grateful, lordship.
He mentioned it in morning. Next.
Serial number 43.
It's very persuasive.
I'm appealing for this one.
My lord. My lord, in this matter, my lord, subsequent to the filing of the appeal, we got certain documents. So on this basis, my lord, we filed a supplementary affidavit. But I'm praying for leave of your lordships. It is ready. It is ready. Leave for your lordships. To
What
file
was
it.
the writ petition?
My lord?
What was the prayer in the writ petition?
My lord, there was a search and seizure. And during that, my lord, amount was taken, my lord. 30 lakhs was taken, my lord, which is not permissible. And my lord, there was search at 2 places. For one place, they produced the authority. For the other places, they could not produce the authority, my lord. So therefore, our contention was the search in the second place is illegal. And my lord, the realization of that, the seizure of the 30
But
lakhs.
there was some direction passed in an earlier writ petition.
It has been dismissed, my lord.
No. The court says, as per the earlier order of this court dated 12/6/2023, in that writ petition,
Yes, my lord.
he produced some documents, ISN 01, and based on that,
My
the
lord,
court came to the conclusion that your allegation is false and baseless.
my lord, those were not produced before we filed the writ petition. We called for the search authorization, my lord, and that was produced at the time of passing this order, my lord. And from that order, we find from what the authorization they issued, it was only for one place and not for the other place.
So this ground was not canvassed in the writ petition.
It could not be canvassed, my lord.
So we will give you liberty to file a fresh writ petition. Because you are trying to non-suit them based on a document which was not furnished to them earlier.
My lord, your lordship will once come to page 81.
Yes.
Page 81. My lord, the second paragraph. On reaching the address as mentioned above, the officers found an office premises measuring about 800 square feet approx, which was declared as the principal place of business of ATR Malleable. During the visit, one person came and introduced himself as Anil Modi, one of the director of Messrs. Such and such. Then the officer showed the official identity card and explained the purpose of their visit on him on search of the principal place of business. After having been seen the search authorization as GST INS 01 such and such issued by the additional commissioner, Huldia Commissionerate, and having taken a honor of the having seen, he put his dated signature on it. Now, in their writ petition, they are saying we have not seen this
No, my lord.
search authorization.
No, my lord. It is not.
There is.
Sorry, I'm sorry.
So that has been given to him and they have annexed in the writ petition.
No, no.
And
My lord, it is not that, my lord. Probably he has misunderstood. My lord, for every search under section 67, my lord, of the GST Act, if the proper officer who's not below the rank of a joint commissioner does a search, he has to be given an authority by the proper.
what happened after the search?
My lord, they collected 30 lakhs of rupees, my lord, they seized, which is not permissible under the GST Act. Secondly, my lord, they say that the INS 01, which is the search authorization, it was only at the time of hearing they showed, which shows, yes,
Have they issued a show cause notice?
No, my lord. No, my lord, nothing.
Then why are you challenging it now?
No, my lord, my lord, my challenge is in this, that the search in the second place of the petitioner had a registered place of business and the petitioner has a factory and an office. They made searches at two places. For one, they could produce a search authorization at the time of hearing. And when the learned judge said that we made a false allegation, no, my lord. For the second one, we could not produce any search authorization. So in the absence of the search authorization.
What has been recorded in page 81 is in respect of the.
My lord, that is what one, my lord, only in one of the matters, one of the offices. I'm not saying anything about that in respect of which the search authorization has been given. But in respect of the premises for which no search authorization was given, my lord, that there cannot be any seizure. The seizure is patently illegal, my lord. And also the issue that needs to be decided, whether at the time under the GST Act, my lord, whether this is the seizure of cash could be relevant for the purpose of the Act. And not only that, my lord.
What is the supplementary affidavit?
But supplementary affidavit is to bring on record what they produced before the learned single judge, which was not given to us before prior to the writ petition, on the basis of which the learned single judge passed this order, my lord. So, my lord, I'm only praying, my lord, I have given them a copy, but since I have not taken the leave of this honorable court, my lord, I cannot file this. So today,
and in this supplementary affidavit, you have raised some additional grounds.
Whatever, my lord, I got it at the time of hearing and subsequently what they have stated. They said we have not done.
Have you raised it? Have you raised additional grounds?
Yeah. We have just annexed it, my lord. Then, my lord, let me finish. Then, my lord, liberty may be given to me, my lord.
No, you raise additional grounds.
Yes, my lord.
Suppose this material was produced at the time of hearing.
Yes, my lord.
And you want to say something on those material. You file a supplementary affidavit raising additional grounds.
My lord. My lord, then after vacation.
All right. At the request of
my lord, after the inspection, summons has been issued to them. They have participated in the summons.
That doesn't matter.
That proceedings can go on.
But my search is legal or illegal?
The learned advocate for the appellant prays leave for filing a supplementary affidavit and also raising additional grounds. As certain documents were furnished by the department during the course of hearing of the writ petition, and the appellant did not have an opportunity to contest those documents. Leave sought for is granted. Full stop. We make it clear that the pendency of this appeal will not be a bar for the authorities to proceed further in the matter in accordance with the. Next.
Serial number 44.
My lord, so it is liberty is given, my lord.
For the respond number 6.
Yeah, my lord.
Yes.
My lord, only one humble prayer, my lord, not in respect of this. My lord, in item number 38, that is Shah Pharaoh, my lord, I forgot to say that pursuant to the order of the learned tribunal, they had issued me a notice for fresh audit. But my lord, I did not participate and because I had filed this. So I'm only praying, my lord, time may be extended for appearing before them.
Same person. They have not taken. Item 35. Which item now? Serial
My
number?
lord, 38. Item 38.
Item 38. It is submitted that one. It can be
My lord,
added.
page 93,
It is
so
submitted by the
lordship
landed
sees.
advocate for the appellant that pursuant to the order passed
আরে
by the
টাইম
tribunal,
চাইছি আমাদেরকে অ্যাপিয়ার করতে
the
বলেছিল না টাইম তো পাস্ট
authority
হয়ে
had,
গেছে
had
আমি
issued
এক্সটেনশন অফ টাইম
notice,
চাইছি
but the appellant did not appear. The time for appearing before the authority is extended. And the authority is directed to issue fresh notice of hearing.
my lord, I'm grateful, my lord. Who's the rich?
No, no, no. It is pending. Supplementary. This can be added in. And item 44.
Serial number 44.
My lord, Mr. Murarka is appearing for the appellant. However, he's left the court premises due to certain illness. My lord, I'm seeking for not today.
Not today. We'll stop with this, sir. Yeah, the other counsel is ready.
May I mention, Lordship? Lordship, serial number 73.
Huh.
Lordship, this is that matter where Lordship has given stay from service tax proceedings and directed the additional chief secretary to hear us and pass appropriate orders. So that 2 months time has expired, Lordship. We have participated in 2 hearings. Now, yesterday I spoke to them. They have told that 15 days they will pass the order. So Lordship, just requesting because after vacation, if it can be fixed because it is running as urgent motion. Any day after vacation, it can be on a Friday, it can be fixed.
All right.
By
Item
that time, the
73.
order will be there.
The item 73.
73, Lordship.
We have heard the landed advocates for the parties. The landed advocate for the appellant submitted that in terms of the interim direction issue, the authority has heard the appellant and the orders are likely to be passed in the next 15 days and prays that the matter may be fixed after Puja vacation. Let the matter appear on 8th December.
Lordship. 8th December. And Lordship, 75. This also your Lordships had directed the state GST to consider the representation. This case was regarding erroneous refund given by the department. Now they are recovering it. So the department has heard us. Now it is finally your Lordship has to decide the number of installments and everything. Because in their order, they have stated that we will not do anything.
So he has passed an order.
He has passed the final order, which has to be placed before your Lordship. My Lord.
So let it remain. We'll see what can be done.
Lordship. Grateful to your Lordship.
Because the other division bench is there.
Lordship. Grateful to
1 o'clock. You permit Mr. Bhattacharya to join. Yes. Yes.
Yes. Lord, this is the matter when Lord, the award was passed by the Honorable Tribunal, which was challenged by the employer. After the Honorable Supreme Court, they failed. Now the award has become enforceable. They are not enforcing in spite of a specific direction from this Honorable Court. That's the contempt we are complaining of. Kindly comes to the award that is at page 107 of this contempt application.
Now, an order has been passed.
Award was passed on 13th May 2014, and thereafter award in my senior.
No. Now, who has given this?
They have supplied me.
You give one copy. Please give one copy.
Not today, Lordship, not today. We have not given it today, my Lord. Had it, perhaps this has been directly communicated from my client's office. I am not sure.
No, 11th September 2023.
3 days ago, my
Yeah,
Lord,
this is this 11th September 2023 is not only without fraud on court, but it's the audacity of the officer to modify the award.
Chairman,
My clients also, I do not.
Client supplied me.
I have no intimation to us, my Lord.
It is not at all a
No,
complaint.
it says it is here therefore ordered that the following persons are hereby reinstated in the corporation under the control of the engaged agency.
Yes.
Corporation, Delta Security Services. And what was the award?
Kindly comes to page 107.
Hold on. 107 to read petition.
No, operative portion of the award.
Kindly takes up the CPAN 622. And the award starts from page 103.
Directed to treat the contract laborers, that is the applicant, as employees of the principal employer.
Yes.
North Bengal. This is wrong, sir.
This is without the direction. They should treat it as employee of the principal employer. And from the date of the award was passed.
I have no knowledge about this, Madam. I have only.
Who has passed this order?
I do not know, Madam.
That is the managing director in BSTC. He has supplied me. Apni client diyeche.
You see the last page. It has been communicated to the advocates also.
Yes.
This contempt petition has been filed.
Lordship, may I submit one thing?
Oh, wait. We are not sending your client into prison.
No.
File for willful disobedience of the judgment and order in FMA number 2147 of 2018 and 2148 of 2018, dated 25/8/2022. The respondent contemnors had preferred an appeal to the Honorable Supreme Court against the said judgment again in SLP in special leave petitions diary numbers 26365 hyphen 20 of 26365 of 2023, and the same was dismissed by the Honorable Supreme Court. After the dismissal, the managing director of the North Bengal State Transport Corporation has passed an order on 11/9/2023, which states that the applicants before the learned tribunal are reinstated in the corporation under the control of engaged agency of the corporation, namely Delta Security Services, New Barakpur, Kolkata.
And that too from the date of the order.
With immediate effect, namely from the date of the order.
Yes.
The order passed by the managing director of the respondent corporation is clearly in violation of the award passed by the tribunal, which was affirmed by this court, and the specially petition against the said judgment was also dismissed. Therefore, full stop. The award of the tribunal was directing the respondents to treat the contract laborers that is the applicants before the tribunal and the the applicants in this contempt petition as employees of the principal employer, North Bengal State Transport Corporation, without any delay. Therefore, the managing director of the respondent has committed a contempt by directing reinstatement of the applicants under the control of the engaged agency of the corporation. This is in blatant violation of the award passed by the Industrial Tribunal,
13 May 2014.
dated 13/35/2014.
Yes, sir.
Therefore, we direct that the managing director of the so-and-so corporation to immediately revoke his order dated 11/9/2023 and comply with the award in its letter and spirit by absorbing by treating the applicants as employees of the North Bengal State Transport Corporation, the principal employer, and such orders shall be passed and given effect to not later than 8th of December 2023. If the managing director fails to comply with the same, he shall appear in person before this court on 15/12/2020.
15/12. My instruction is otherwise. 14 September 2022. They have sent to finance department. Problem is that, my lord.
Yeah, this is all modus operandi, sir. This the security services.
Lordship,
We have arrested all those directors. You please ask Mr. Somya Mazmundar. He was appearing.
Yes, Mr. Mujumdar appeared.
Yes.
I go through.
We have arrested all those directors.
Only yesterday I got the brief from the GP.
And that particular contractor, he does not have a registration under the Contract Labor Abolition Act. And your transport corporation, Kolkata Municipal Corporation, all government agency, he is the sole contractor. What is all this? And he is liable for prosecution if he is not. And the commissioner, the managing director, they are also liable for prosecution for having engaged a contractor who is not registered. We have made such observation that those laborers were suffering only after we passed an order of arrest. Midnight, they arrested them, 4 directors. Immediately, they paid the money.
It is not.
Tell your managing director,
I am
if
not
he doesn't
supporting.
comply and he comes on 15th here, he will not go back to his office. He will not go back to his house, but he will go to the correctional.
I'm grateful.
Please tell this fell from the court. It's a very serious matter.
Definitely, my lord, I shall buy out your lordship. My lord, my specific instruction, they are processed under the finance department.
What do you mean by person?
It is all from 2014 was the award.
That is that.
You have dragged the matter to the maximum possible. Single bench dismissed the writ petition. We have dismissed the appeal. Supreme Court SLP dismissed. Whether Section 5 dismiss or dismissal is dismissal.
Now has to.
And thereafter, you please surrender. Please be magnanimous and implement. Otherwise, what we will do, we will attach about 30 buses. And we'll ask the 30 buses to be come and park here.
No, it's a very.
Please
very
advise them.
serious.
Please advise.
My lord, 26/9/26/11 আমি আপনার কাছে মেনশন করেছিলাম, আপনি বলেছিলেন আমার ম্যাটার CO1147
এই বেঞ্চ
দাঁড়ান দাঁড়ান মাই লর্ড 3 তারিখ আমি মেনশন করেছিলাম।
আচ্ছা ঠিক আছে।
3 তারিখ মেনশন করেছিলাম, ফার্দার আমাকে আমার ম্যাটারটা যদি একটু অ্যাসাইন করে দেন।
Yes.
3 তারিখ আমি মেনশন করেছিলাম।
You tell the voice.
হয়ে যাবে।
Yes, sir.